Can you see me?
I can't yet, ma'am.
Okay.
If you
I'm
can't
always
figure
having-
it out, that's fine. I was just hoping that you would both be able to appear on video for this, but
Yeah, I'm trying.
okay, let's go ahead and call the case. Are you ready, Ms. Greenwald?
Yes, sir.
Court calls number CVPC-22-000254 in the interest of Brady.
Yes, Your Honor. Good morning. Emily Kyler Green for the department.
Bianca Studebaker, Permanency Specialist.
Ashley Crouch, Acting Permanency Supervisor for Belong.
Richard Saldivar, attorney for Ms. Heather Harms, the mother. Ms. Harms, can you announce, please?
Yes, Heather Arms' mother.
Deborah Fuller, attorney for the father, Eric Chavarria. Mr. Chavarria, could you please announce?
Yes, Eric Chavarria here, father of Braden.
Carol Collins, attorney ad litem for Braden.
Your Honor, Mark Witcher, CASA volunteer.
And Goldie Rabson, Hill Country CASA guardian ad litem supervisor.
Thank you. All right, we're here today for a dual setting, permanency and final. It's my understanding the parties have an agreement for final orders, however, do have one issue as to child support. Is that correct, Ms. Kyler Green?
That is correct, Your Honor. The parties met and have a Rule 11 agreement for everything except for child support.
All right, if you would, I don't know if you want to share it.
I can.
And I've allowed that. And then if you could lay out the terms and conditions of the Rule 11 agreement, please.
Yes, Your Honor. Are you able to see?
Yes, ma'am.
Okay, so the parties met on January 30th, 2023, agreed that this is binding and non-revocable, that the agreement's in the best interest of all parties agree that respondent father Eric Chavarria may change the name of Braden to Braden McKee's final trial. The department agrees to name Eric as the sole managing conservator of the child and the respondent mother, Heather Harms, as the possessory conservator. The parties at this time agreed for the mother to pay minimum wage child support starting the first day of the month. However, Ms. Harms was not present at this Rule 11. The parties agree that the mother's visitation will be twice monthly, supervised by a respondent father or a mutually agreed supervisor. Visitation shall be at the time and place to be determined by respondent father, and that respondent mother is to confirm visitation within 48 hours prior to the visit. And this visitation between the child and the mother is at the discretion and desires of the child. And all parties agree that their electronic signatures are binding.
Let me read the visitation one more time, please.
Yes, sir.
And what's the department's position on child support?
Well, the department was in agreement that child support be paid minimum amount for minimum, or excuse me, the statutory amount for minimum wage. I don't actually know what the respondent mother's position is as to what her child support should be. I just know that she wasn't in agreement with that aspect of it. That's all I know.
Let's exclude the child support amount for the moment. Mr. Saldivar, is that your understanding of the agreement?
Yes, and just to clarify for the record, Ms. Harms wasn't at that meeting, Judge, so we're not able to agree. And I did discuss the order with her afterwards. I believe, and if she can confirm on the record, that she's in agreement with those terms other than the child support.
Yes, I agree.
All right, why have you, Ms. Harms, you heard the entire agreement with the exception of the child support?
Yes, yes, I have.
You understand it?
Yes, I do.
You had the opportunity to discuss it with Mr. Saldivar?
Yes, I did.
Were you forced to enter into the agreement in any way?
No, sir.
Were you made any promises or inducements?
No, sir.
Are you asking the court to approve the agreement with the exception of the child support today?
Yes, sir.
Okay. Ms. Fuller, is that your understanding of the agreement?
Yes, Your Honor.
Mr. Chavarria, is that your understanding of the agreement?
Yes, Your Honor.
Do you have the opportunity to discuss it with Ms. Fuller?
Yes, Your Honor.
Do you understand it?
Yes.
And were you forced in any way to enter into that agreement?
No, sir.
Were you made any promises or inducements?
No, sir.
Are you asking the court to approve the agreement today?
Yes, sir.
All right, Ms. Fuller, what's your client's position on child support?
We would ask that the mother pay minimum wage child support under the, based on, the Texas Family Code and her requirement, her obligation to support her child. We would also ask that she pay the $25 a month in medical support to ensure that Braden is able to keep his Medicaid. And we feel that we're not aware of if she's working or not, but that is the least amount of child support that would be expected of a parent in this situation or in any situation. So we would be asking for the minimum wage and then the $25 in medical support.
Ms. Collins, is that your understanding of the agreement?
Yes, Your Honor, totally is. I have discussed it with Braden as well. He does want his last name changed. He does look forward to seeing his mom, hopefully in March, he said. Also have talked to Mr. Chavarria just briefly, or he volunteered to say that, yeah, that sounded fine. He will supervise. He doesn't want the visit, of course, at his home, but he might even drive to the local area so Braden can see his brother. I think that's just about the only thing. I don't know if we put in there that there should, it just brings to mind, if we have in there, there should be visitation between him and his brother Case, because I think it is in the other order with Case, but whether it's there or not, I know Mr. Chavarria is going to see to it that Braden sees his brother. I have no doubt about that.
The only reservation I would have about putting it in this order is that it would, I don't have jurisdiction necessarily over that other order anymore. But I don't have any objection, if none of the other parties do, to authorizing, obviously, Mr. Chavarria to engage in that visitation. Mr. Saldivar, your client doesn't have any objection to that?
I don't believe so. Your Honor, Ms. Harms, do you have any objection to that?
No, sir.
And Mr. Chavarria has no objections to that. He's encouraged to know that they're willing to have visitation with Braden, and Braden would like to see his sibling.
Okay. Casa?
Yes, sir. Your Honor, we're understanding in agreement with the agreement, and particularly the case Braden visitation. Where they had begun to visit before the move to Rockport and understood the difficulty with ordering it. But I've talked to Mr. Chavarria, and he has expressed a real interest in making sure that continues. So we fully support that as well.
Okay. Thank you, Mr. Witcher. Ms. Studebaker, you're the caseworker now?
Yes, sir.
Do you believe that this agreement is in the best interest of the child?
Yes, sir.
Mr. Saldivar, as you know, the family code requires that the judge, in a case like this, order child support, find that it's in the best interest of the child, unless there's some other evidence that suggests that it's not. Have you discussed that with your client?
Yes, Judge. I believe she understands that her position, and if I can call her if you need more evidence, Judge, is that she's not working at this time. She's unable to meet the child support obligation at this time. And so she's asking that to be waived, that she can work something out with Mr. Chavarria. I think they're on good terms, Judge, and she can provide if Mr. Chavarria asks her to. And if the court does issue or order child support, Judge, I'd like you to take into consideration that she is paying child support on the other child as well. So it'd be based off 2 children.
If my understanding is correct, what you're saying is this, if I were to order child support in this case, it would be based off a computation that took into consideration she had one other child not before the court today for which she already had an obligation.
Yes, Judge, I believe the prior final order on case had her at minimum wage child support, Judge.
Your Honor, if I might, I would like for the mother to pay child support. I believe that he's paying it for Kate. She's paying it for Case. She should likewise pay it for Braden. It's not based on the economic need of the father or the grandparents. but I believe it should be his obligation to help, her obligation to support her child.
Thank you, Ms. Collins. Anything further from anyone before I make a ruling?
Judge, just if you need me to call Ms. Harms to explain why she's unable to meet her obligation here and also the issues that she's having paying cases child support.
I'll allow it. You can ask her a few questions.
Okay. Ms. Harms, can you please explain to the court why you're asking that child support be waived here in this case?
I'm having I don't really have a job quite yet. I took care of him for nearly 12 years on my own and never asked for a dime for child support. And I believe if Eric needs help, I will be there to help him with whatever he needs help with whenever the time comes. But as for now, once a month, I mean, if he needs it, I'll pay it, but I'm not going to be able to pay most likely every single month unless it's absolutely needed. I don't want to
Okay.
have an order on it in case I can't, you know what I mean?
And since you were ordered to pay child support in the case of your other child case, have you had issues paying that child support?
Yeah, well, the grandmother and I have made an agreement that whenever the time comes, if need be, to help her with that, and I'm absolutely welcome or open to it, absolutely. But she hasn't asked me anything yet about that, so I have
Okay.
money, I just not a lot.
Okay.
So,
Any other information that you want to disclose to the judge about child support?
no, sir.
Okay, pass the witness, Judge.
Skylar Green, Cross.
No questions, sir.
Ms. Fuller.
Ms. Harms, I represent Mr. Chavarria. Was it your testimony that you're not paying child support in the other case?
Yes, ma'am.
So
Unless-
were you ordered to pay child support?
I think it's between the grandmother and I, from what I understood.
Okay, so you understand that you have, under the family code, that you have an obligation to support your child, correct?
Correct. And yes.
And initially you did not provide information that Mr. Chavarria was the father. You named someone else as the father, so his obligation would not start from the time until he was established as the father, correct?
I'm not quite sure I understand what you're saying.
Yeah, I kind of confused
Yeah,
myself too. So
That-
in regards to that question, initially you had claimed that someone else was Braden's father, correct?
Right, the man who was with him his whole life. Yes, ma'am.
Okay. And so Mr. Chavarria was just recently established as the father.
Yes, through DNA
Okay.
testing. Yes, ma'am.
Yes. And so it's the child support. Do you understand child support is not about whether Mr. Chavarria needs it. It's about an obligation to your son, and the child support amount would be an obligation to your son.
Okay, yes, ma'am.
Okay. And a minimum wage would be a minimal amount of child support to be paid for a teenager, don't you think?
Well, yeah, $25 isn't a whole lot. I agree with that.
Well, the $25 is actually the medical support that the Attorney General requires for someone to maintain Medicaid. And so that's in addition to the child support.
Okay.
Okay. So, but you do understand that as a parent, that's your obligation to support your child.
Yes, ma'am.
Thank you, Ms. Harms. I'll pass the witness.
Ms. Collins.
Thank you, Your Honor. Good morning, Ms. Harms. I'm
Good
just
morning.
looking at the final order regarding case, and it does order you to pay $194.74 per month for the supportive case beginning December 1st, as well as medical support. That's regarding case. Don't you think you should be ordered to pay the same amount for Braden as you were previously ordered to pay for case?
Yes, ma'am.
Okay, thank you. Pass the witness, John.
Any other evidence? Court finds that it has jurisdiction over the subject matter and the parties of this case. Court finds that the court has exclusive jurisdiction, continuing exclusive jurisdiction of the child of this case based on prior proceedings. Court also finds that no other court has continuing exclusive jurisdiction that I am aware of. Court finds that the parties have entered into a Rule 11 agreement. Court finds that the Rule 11 agreement is in the best interest of the child. Court will adopt and approve that agreement. One clarification I have, I understand the agreement permitted by agreement Mr. Chavarria to change the child's name. Was there a petition for name change filed set for today?
No, Your Honor.
Right,
We
is there-
agreed based on the DNA testing that established him as the father, that we would change his name.
Okay, so is there any objection to, well, first of all, is there a oral motion for the name change of the child to be heard today?
Yes, Your Honor.
Is there any objection?
No,
don't
Your
think so,
Honor,
Your Honor.
that's
No,
what
Your Honor.
Braden wants.
Yeah, no, Your Honor.
Okay. Then pursuant to the agreement of the parties and the oral motion of Ms. Fuller, having heard no objection, the court will change the child's name to Braden. And let's include that in the order, final order, Ms. Kyler Green. Court will name Mr. Chavarria to be the sole managing conservator of the child. Court will name the mother to be the possessory conservator. Court will order the mother to have visitation pursuant to the agreement twice a month, supervised by Mr. Chavarria or a mutually agreed person to supervise. Court will order the mother to confirm visitation with the child 48 hours prior to the visit. Harms, I want to make sure you understand that's 48 hours ahead of time. It's not 38 hours and change. It's 48 hours.
Yes, sir.
Visitation will occur at a place to be determined by Mr. Chavarria, and the visitation will also occur pursuant to the agreement of the parties at the discretion and desires of the child. I'm reluctant sometimes to order something like that, but the parties obviously discussed it and agree that that needed to be part of this order, so I'll approve it. There's been discussion of visitation with his brother case, so I'd like to have it in the order that that visitation is authorized as far as this order is concerned. Obviously, as I said earlier, I no longer have jurisdiction over the other child, so I can't enforce that order from that end. Regarding child support, Ms. Fuller said the same thing that I was thinking in my mind, is that the obligation for child support is not based on the financial circumstances of the obligee, and it's not based on the circumstances of the child. It's based on the minimum guideline, or excuse me, the guidelines in the family code for the obligor. And in this case, the court will order child support to be paid by Ms. Harms to Mr. Chavarria, but I'm not going to begin that obligation until April the 1st of 2023. So that gives Ms. Harms plenty of time to figure out her employment situation. Ms. Harms, I understand that you might have some sort of agreement with the party in the other case, and you may have some sort of agreement with Mr. Chavarria, but the reason child support obligations exist and the legislature found it necessary to put it in the family code is because situations change and it needs to be specific and it needs to be enforceable. And that's for the benefit of the child, not the benefit of either parent.
Yes,
Going to
sir.
order minimum wage child support to begin April the 1st, 2023, along with the $25 cash medical support. Obviously, the guideline minimum wage child support needs to take into consideration in the calculations that Ms. Harms already has another child for which she has a duty to support that's not before the court today. Does somebody have that amount?
Your Honor, I was just going by the order in the other case, and it should be the exact same thing in this one because we've got one child before the court and one not. So, and that amount was 194.74.
That sounds correct to me because I believe at the 20%, it would be around 250. So at the 17.5, it should be around the 191 plus the $25 cash. So what was that exact amount again?
194.74.
All right, that'll be the child support ordered by the court for Ms. Harms to pay beginning April 1st, 2023, along with the $25 cash medical. All right, Ms. Kyler Green, is there anything I've failed to address?
Your Honor, I don't think it's actually been mentioned for the department to be dismissed.
Department and all attorneys ad litem and guardians ad litem will be dismissed by virtue of this order. And there will be no further hearings. Anything else?
No,
Your
Your
Honor,
Honor.
thank you.
Well, I want to say
Your
thank
Honor.
you to everybody for working so hard to come to this Rule 11 agreement, to come to an amicable resolution of this case. And I'm really proud of you, Mr. Chavarria, for getting into this the way you did and stepping up and being a dad. And Ms.
Yes, sir.
Harms, I hope that you and Mr. Chavarria can work together. And the greatest thing you can do for Braden in this case is to get along, and anytime you have a disagreement, to work it out without him ever knowing about it. Okay?
Yes, sir.
All right.
Yes, sir.
Thank
Your
you all
Honor,
for your service.
I just wanted to say something too, that I am very proud of Mr. Chavarria as well for stepping up and really being involved once he, was determined that he was the father, and he's done everything, and Braden does want to see his mom, and I'm sure that they will work it out. And I'm glad that he's, agrees to that as well. He is doing everything that's in Braden's best interest. And I really do want to congratulate him on all his efforts.
I echo your sentiments. Thank you all. Good luck to you. That'll be the order.
Thank you.
Nothing further. All parties are excused.
Thank you.
Thank you.